Yes, Ms. Fatima.
My Lord, I was going to address the second knowledge failure, which relates to the judge's reliance on documents.
Sorry, say that again, I didn't hear you. You're going to?
The second knowledge failure.
Yes.
The judge's reliance on documents which we had not seen before the collapse. And that's paras 72 to 73 of our skeleton. I've referred to tables that we had submitted because a key part of our defence was to establish the limits of the information which BHP actually received or saw before the collapse. And I said I was going to show you those tables. So could I just do that? It's tab 14 of the supplementary bundle. And it's the first one is K2/1.463. And you can see that that's table 6, which relates to FMEAs.
Page?
63, my lord.
Sorry?
63.
63. Yes.
And so you can see that that shows the receipt of by named individuals of FMEAs in relation to the dam in that table 6. And if you can continue in the same document to page 69, you'll see a similar table, table 7, and this is named individuals in receipt of documents in the Geo Annex A prior to collapse, and that's quite a long document. If you can just get a sense of it, you will see that again that indicates who had and indeed who had not seen these documents.
Yeah.
My lords, again, like all of the Samarco evidence I showed you earlier, these tables were not challenged by the claimants, and the judge made no findings contrary to them. The judge did, however, refer extensively to material which these tables showed that BHP never saw before the collapse. And it appears from the judgment that the judge relied on that material for the purposes of her findings of knowledge and fault. The section begins at 655, but could we just pick it up at the end of that survey by the judge, which takes us to...
Can I just check? I just want to check I understood you last. You said the judge referred extensively to material which the tables showed BHP never saw before the collapse.
Yes.
Is that because they're not in the table, you mean?
No, she's referred to documents.
So some of the FMEAs that have no against.
Yes, and table 7 documents as well.
Table 7
yes,
as well.
Exactly.
So other than the ones that are green, I see now what you mean.
Yes. So the part of her judgment that deals with this starts at 655, but could we pick it up at 792, which is page 167, and this is the end of that survey of the material. Yes. Yes, sorry, I said it starts at 655. That's where she refers to the material allegations of fault, and that's where she refers to reliance on reports as to stability of the dam. That section on the reports as to the stability of the dam starts at 743, ends at 792, and you can see there that she says the information available prior to the collapse, far from offering comfort as to the stability of the dam, indicated or should have indicated the need for a liquefaction study in respect of the condition of the dam. And she sets out there, you can see over the page, 11 sub-paragraphs of material. Now, my lords, the bit that I just read out...
the 792 part.
Yes, that the indicated or should have indicated the need for a liquefaction study, that sounds to us very much like it is part of the judge's analysis of the issue of what BHP knew or should have known. I raise that because in the consequentials judgment, the judge described this analysis as relating to documents that were only relevant to what a counterfactual study would have shown. we don't understand that given the framing, given the need for a liquefaction study, because that doesn't seem to us to relate to what a counterfactual would have shown, assuming it was obtained. And so we have read this section as indicating that it relates to that question of knowledge, and we read that in light of 793 as well. If you go on to look at that, you will see that the judge says that there is a clear inference to be drawn from the report and to the recommendations in the report not being followed. And then if I just show you, again, to explain why we've interpreted the judgment this way, if you please go to 804, which is page 170, you will see that in the conclusions on false liability section, she refers to obvious deficiencies in the VOGBR reports. And so again, the judge appears to be making the point that BHP knew or should have known of those deficiencies. And similarly, in that paragraph, the references to the overwhelming thrust of the other contemporaneous reports sounds like these reports are said to be relevant to BHP's knowledge. And then finally at 806, you can see the conclusion that BHP's negligence is said to be failing to carry out the above studies and remediation actions recommended by experienced engineers. And again, that appears to us to refer to, or at the very least to include, the recommendations we saw in 793. We therefore submit that a fair-minded reader of this judgment would understand that the judge was relying on the material in that section of the judgment from paras 743 to 792 in support of her findings on knowledge. And could I just take you back for a moment to 792 on page 167, and those, that the list that's set out there. And my lords, it may be helpful for the court to know that BHP did not see the material at 8 of these 11 subparagraphs. So numbers 1 to 5, 7, and 10 to 11. We did not see that material. And again, I emphasize that the evidence was before the court in the tables. It was not challenged and it was not referred to in the judgment. Quickly, my lords, the third knowledge failure, which is the last one I just want to say something about, that relates to the judge's failure to address our objections to the claimant's attempt to run unpleaded allegations of audit negligence. And we've addressed this in our skeleton at 74 to 77. It was a key part of BHP's case in closing that the claimants were trying to run this case. And my lords will see that if I just give you the references to our written closing, which you have at tab 18, we addressed it in the beginning of that document at paras 23 to 38 and extensively over section 83.6, sorry, K3.6. And my lords, within that section, K3.6, we addressed specifically what was alleged about the FY14 or 2013 Samarco audit, because that was.
Can you give me the reference again, Ms. Fatima?
Yes, my lord. Are you wanting the specific K3.6 reference?
Well, I'd quite like the reference about what you were talking about.
So 23 to 38 in our written closing.
Your closing paragraph.
Yes, paragraphs.
Yep.
Which is page 11 onwards. And if my lord has a look at that, you'll see that that's an initial section where we're explaining
Yes.
the need to have, you won't be surprised to know, a pleaded case, especially for serious allegations of negligence. But then if I could ask you to go on to section K3.6, which starts at 335.
Para 335.
Page 335, my lord,
Page.
and it's a heading, which I hope you see. It's Alleged Illicit Act 6, BHP's audit. And then within that, the bit in particular that I was flagging starts around 1035, para 1035.
Para 1035 in your closing. So
Right,
over the
yes,
page on
yes.
pleaded case.
And that can you see there, there's a reference and the heading and then in the paragraph itself to the 2014 audit.
Yes.
So that was the key audit. And you can see, if you just turn the pages, all of this is our submission on the merits of that allegation, as well as explaining to the judge why these were unpleaded and how the case had evolved. So we dealt with it in considerable detail in writing. Mr. Toledano, King's Counsel, then made oral closing submissions on this point, again, in some detail. And the reference, in case the court would be assisted by that, is L2 4736, which is tab 33 of your supplementary bundle.
Right, now, do you want us to go there or not?
I'm simply giving you the reference to indicate that there were considerable oral submissions on this point as well, my lord, extending over several pages of the transcript. The point being that this was a central part of our defence of the fault liability case. The assertion that these were unpleaded allegations and that the claimants should not be allowed to run them in the way that they had sought to do so. Can I show you how the judge resolves this? This is in paragraph 654 of the judgment, page 135. Legitimate concerns have been raised by BHP regarding the evolving and changing nature of the illicit acts relied on by the claimants. The material allegations considered below have been pleaded, but it must be said that at times the path through the pleadings to find them is somewhat tortuous. My lords, those two sentences are the full extent of what the judge said in response to all the written and oral submissions I've shown the court. There's no reasoning or attempt to identify where the specific allegations which BHP had complained about were pleaded, and there's no reasoning or attempt to identify where the judge considered the material allegations, which she then went on to consider, and which obviously I've been addressing you on, were pleaded. And we rely on that as the third knowledge failure, but also on the fact that she did not then address the merits of the submissions that we actually made on those unpleaded allegations. So those are the third and fourth knowledge failures. Can I just, before I leave fault, address one point which is made in the claimant's skeleton at 46? One of the things that they have said in their para 46 is they say that the pleading objection did not matter because the judge relied on sources of knowledge other than the constructive knowledge via audit negligence for her findings of BHP's knowledge in relation to the beach width violations, the lack of design for a setback, and the lack of a liquefaction study. My lords, we say that that explanation doesn't go anywhere for four reasons. First of all, I've already shown the court earlier today the very limited other sources that the court relied on for those findings, and I've also shown you how they are infected by the failures to engage. So the material that the claimants say the judge had to rely on was in itself, we say, tainted by that failure to engage that I've made submissions on. The second point is, it is impossible to disentangle the findings in the way that the claimants seem to be suggesting, because the judge's reliance on findings of audit negligence in the judgment are, as I have shown you, extensive and permeate each of the five things that she made findings about. Third, the claimant's approach is unfair. If, as we contend, the claimants were not entitled to run a case of audit negligence, then the solution is not to excise the findings of audit negligence from the judgment to try and save what remains. The facts need to be looked at again, and that is clear when the court recalls what our case was. Our case was that the actual result of that contentious 2013 audit was a point in our favour on the issue of knowledge. And that is because BHP knew that an independent expert, Dr. Gaga, who had carried out that comprehensive review of Samarco's management of its tailings dams, had not identified any serious concerns, whether in relation to beach width, the setback, or the liquefaction. And so we say that if there was no allegation of negligence, then the audit result was a point in our favour. And that is why the claimant's approach simply doesn't work. Fourth and finally, they refer to the tables of references that they produced on this pleading point. That goes back to the debate that we had this morning about what the oral evidence shows and what the transcript shows, in terms of the merits of whether or not they can now show that actually this was pleaded. In our submission, that is not something that this court can engage with at this permission hearing. The critical point that I have already made is nowhere does the judge engage with what the claimants relied on to justify the conclusion that I have shown you. So we simply don't know what she made of their submissions on that point, and that is why they can't now rely on them. So, my lords, that...
Can I just check what you mean? I want to be clear. You're saying we shouldn't look at what the oral evidence shows at the trial and the other elements that have been submitted by the respondents, because why? Surely that's what we have to do, don't we?
My lord, as I said this morning, in my submission at this permission stage, this court is not able to resolve for itself who is right about what the experts said and meant, and who is right about whether or not things were pleaded. And we, for our part, do not ask you to make that finding on either of those two things for this reason. Both of those complaints, ground 1.1 and ground 2, are failure to engage appeals. And our critical point on both of them is whatever the judge found, none of us know, because it's not in the judgment. We have conclusions, often in a sentence or two, but we don't have reasoning. We don't know what she made of our submissions on Professor Sarlett's evidence. We don't know what she made of our submissions on the claimant's unpleaded allegations. And that is the point that I'm making. There is a separate question which would fall to be assessed if permission was to be granted in relation to ground 1.1 as to who has the better of the argument on the transcripts. But my lords, in my submission, that is a fight, if it is to be had at all, for another day.
Understood.
Could I turn then to limitation? There are 3 limitation grounds. Each are based on both failure to reason and plainly wrong. Turning first to Article 200, we address this from paragraph 88 of our skeleton, and as we explained, there are 2 determinative issues. I'm going to make submissions on the first of those, which is the parties issue or the vicarious liability issue. So as we explain at paragraph 90, it was common ground that Article 200 could apply to a civil claim against the employer of a criminal defendant if that claim was to enforce the employer's vicarious liability for the criminal act. The critical debate was whether Article 200 could apply to any civil claims against an employer that were not based on vicarious liability. And BHP's case was that it could not. This was a determinative issue on the facts because, as the court will know, the claimant's claims are not vicarious liability claims. I want to start with the expert evidence before turning to the judgment. In terms of the written expert evidence, my lords, in their reports, the evidence of both of the experts on this party's issue was that Article 200 applied to claims against either the criminal defendant themselves or claims against others imposing vicarious liability for the criminal act. And my lords, it is important to stress that the written evidence did not go further than that. So Professor Tepedino's written evidence, he was our expert, was that Article 200 operated personally, that is, to the criminal defendant. And he went on to explain in his second report that this included the situation where a third party was strictly liable for the criminal defendant's conduct, i.e. vicarious liability. Professor Rosenbaum's written evidence in respect of third parties was limited to cases of strict or vicarious liability. So that was the written evidence. And as we explain in paragraph 92 of our skeleton, the way the claimants sought to address this problem that they had on the facts was by proposing what they submitted was a logical extension of the Brazilian law. And the nature of the extension they proposed developed during the course of the trial. But the case they ultimately put to Professor Tepedino and that they advanced in closing was that Article 200 should apply to anyone who is jointly and severally liable for the criminal act.
Whether they're the criminal defendant or not, or vicariously liable or not, that's the real issue, isn't it, on this? Is could it be extended as though they were the criminal defendant, even though they're not vicariously liable?
Essentially,
Yeah.
essentially, my lord, yes. But the argument that was then developed, the joint and several liability argument by the claimants, had no basis in their written evidence. Instead, it was said by the claimants to be supported by their experts' oral evidence. And in that oral evidence, he said that Article 200 had not been applied to third parties outside of vicarious liability, but that there was, I quote, no impediment in thesis, as he put it, to it being applied. So that was the oral evidence that he had given. That evidence was then put to my expert, to Professor Tepedino, in cross-examination. And I want to show you Professor Tepedino's cross-examination on this point. It's L2, tab 29, page 6.
Which means it's in our supplement, third volume of our supplement.
Yes, I think so. I'm so sorry, I don't
No,
know
no,
what your
don't
tab
worry.
number is.
I'm using a hybrid of hard copy and electronic, so it's not your fault. Yeah, thank you very much. On day 36, is that right? I think.
29, day 29, my lord. So it's L2, tab 29,
Yeah.
page 6. And the relevant passage begins at page 19, line 13, where I hope you can see on the question of parties
Sorry, page 19.
in the actual transcript, my lord. So
I think it's not tab 29 though, is the issue. I think it might be tab 26.
Right.
But just bear with me 1 second because I was looking at this. I think it's L229, page 6 is the opus reference, but where tab 26, second substantive extract, which has internal numbering of the 4 pages, 17, 18, 19, 20.
yes,
Is that right?
that's it, my lord. Thank you very much. And it's page 19,
Yeah.
line 13, on the question of parties.
In the Portuguese.
On the question of parties, can we go to your first report in the Portuguese? Yes. So there are 5 pages of the A4 transcript that deal with this. I'm just going to show you 2 passages. So if we could look at page 20, line 12, and you can see the question, do you now accept, contrary to what you said in paragraph 460, that the interruptive effect can extend at least as far as corporate lawyers to the state of Brazil and to institutions such as churches and so on? And Professor Tepedino says, I apologize, this is a sophisma, there is an imputation link. It was asked to me by a colleague, and the imputation link attributes the personal interruption. Interruption suspension is personal, and it is the imputation under, that's a reference to Article 932, and imputation can be on the employer or others, and that has to be the suspension or not, which is personal for us to impute under the law. It is the law that imputes. And that's that relevant passage on imputation link. What he calls the imputation link is the need for it to be vicarious liability or personal to the defendant. That's how he's referred to it throughout.
Yeah, which he explains by reference to his analogy about his son committing a crime.
Exactly.
Even though he was
Exactly.
18.
Exactly so, my lord. And then the second passage is page 25, and the question starts at line 2. And we see here the claimant putting to Professor Tepedino their own expert oral evidence. So claimants are saying Professor Rosenbaum's oral evidence was that the STJ hasn't yet had to confront situations in which Article 200 was sought to be applied outside cases of vicarious liability, employment and agency. And then if you look at, so the reason I'm showing you that, my lords, is that it's common ground, that the claimants are saying that their own expert has not identified an STJ case in which Article 200 has been applied outside vicarious liability. That's the reason for showing you this bit of the transcript. And then if you can look at the question at line 16, Professor Rosenbaum's evidence was simply that the STJ hasn't yet had to deal with the fact pattern of a civil claim where there wasn't a relationship of vicarious liability. Do you agree that that's the current state of the STJ law? So again, my purpose in showing you this is to show you the claimant's own position. So they themselves are saying that their expert acknowledged that there was no STJ case that had applied Article 200 outside vicarious liability.
It's quite a
You
sorry.
said, I think, that Professor Rosenbaum said there was no impediment to that happening.
He said there was no impediment in thesis, and I'm going to come on to consider what that means. But my lords will appreciate that it is critically important that it was acknowledged on both sides of this case that there has been no STJ case that has applied Article 200 outside vicarious liability. That is what this judge has done, and we will come on to look at the basis on which he has done it. But that is why I'm showing you this part of the transcript.
But before we get there, it's quite a simple point, isn't it? There is authority that shows for vicarious liability it's extended. There's no authority that shows it can be done or has been done. And your point is it's an exclusive set. It has to be vicarious liability. That's a very self-contained point of principle, isn't it?
It is, my lord. But critically, there's no STJ authority
I
of
think,
that.
well, I think
Yes.
we've got that point. So there's no established authority that shows it can be done. There's then just different discussions in the evidence about the theory of whether it can be done, but it's never been done before.
It's never been done before.
So is the vicarious liability merely a subset of a wider way it can be done, or is it the complete set of how it can be done? This is a very straightforward point.
Provided that, as the court has indicated, you've got the point that there's no STJ case law, because that is obviously what this court has got to.
I can assure you we have got that.
Yes, and so, my lord, it doesn't matter in my submission
I understand.
what the academic.
I'm not necessarily disagreeing with you.
Yes.
I mean, the academic analysis is really academic hypothesising.
Exactly so, and so I just want to be clear that yes, you're right, absolutely, my lord, that is the debate.
Not necessarily putting it as a point against your
No,
argument.
I
I'm just
understand.
stripping it back to what
Yes.
it really comes down to.
Yes. Yes. My lords, can I take you now to the judgment? 833, paragraph 833.
Paragraph
833, my lord, which is page 174. This is a description of our case and Professor Tepedino's evidence. And I just want you to have a look at the last part of it, which is further, the suspension in respect of Article 200 applies to civil claims in respect of the liability of the criminal defendant and will only apply to civil claims against parties other than the criminal defendant where those claims are to enforce vicarious liability for that criminal act. So the judge knew that that was our case because she described it in those terms. Can we then look at the conclusion in paragraph 860, which is on page 180, and it's in the final sentence. And this is the only reference in the judgment to the conclusion on this issue. In cross-examination, Professor Tepedino suggested that a criminal prosecution of an individual would stop time running for the purposes of a civil claim against the individual and their employer. So that's the analysis that we get. And then could we also just look at the consequentials judgment, paragraph 69, Roman 2.
But just before we do that, just pausing there, that last sentence, you would say, I imagine, that's nothing to the point. It might be accurate that you did agree that, but that doesn't deal with the extra vicarious liability.
No, it doesn't.
Sorry, and then we're going to go somewhere else.
We're going to just look at the consequentials judgment, paragraph 69, Roman 2, which is PTA 1C tab 8, page 15. And the judge says there that the court did engage with the application of Article 200 to non-parties to the criminal investigation or proceedings. The court was entitled to rely on Professor Tepedino's concession in cross-examination on this point. So, my lords, reading those two passages together, the judge has concluded that Professor Tepedino had a position on the parties' issue, which was then conceded in cross-examination, and the concession was, as I read out, a criminal prosecution of an individual would stop time running for the purposes of a civil claim against the individual and their employer. And there are three significant errors, we say, in that conclusion. First, these passages don't resolve the issue before the judge, and they indicate that she appears to have misunderstood it. So we saw that the judge had correctly identified our case based on Professor Tepedino's evidence, which was that Article 200 will only apply to civil claims against parties other than the criminal defendant, where those claims are to enforce vicarious liability. I showed you that. She set it out at 833. So the dispute concerned the nature of the civil claim against the third party. We say it has to be vicarious liability. Now, the purported concession that Professor Tepedino has said to have made is that Article 200 will apply to a civil claim against the employer. That does not answer the question. That does not answer that dispute, because a vicarious liability claim is obviously a civil claim. So put another way, the judge does not say that Professor Tepedino's concession was that Article 200 will apply to any civil claim against an employer. And that is the response to my Lord Justice Fraser's point that that bit of the cross-examination is not a concession. It does not deal with the point. So
Well, it's not wrong, it's just doesn't deal with...
Exactly
you
so.
say it doesn't deal with the point.
exactly, it's the difference between a civil claim and any. And so, my lords, the central dispute is left unaddressed and it seems to have been misunderstood. But second, we say the judge's conclusion indicates a misunderstanding of the evidence because there was no concession. And as a matter of general fairness, it is reasonable to expect that a court will identify evidence that is said to be in the nature of a concession. And that expectation, we would say, is all the more justified if the concession is a significant one, as this one is. My lords will, I'm sure, have appreciated that the parties' issue is very significant. Because if BHP are right then 423,000 claims are out of time. Now, given the significance of that point, in our submission, it is nothing short of remarkable that the judge did not identify the passage of cross-examination either in the judgment or after I had made submissions on permission to appeal before her in the consequentials judgment. And that is plainly extremely unfair to the defendants. I should add that no concession has ever been identified by the claimants, not in the December consequentials and not for the skeleton for this hearing. But third, leaving to one side Professor Tepedino's evidence, it remains the position, as I have shown you, that the claimant's own evidence acknowledges that the STJ has not applied Article 200 to third parties outside vicarious liability. Professor Rosenwald's evidence was that he saw no reason in principle why it could not be applied beyond vicarious liability in the future. So at most, he was positing a rational development of Brazilian law. But as this court will know, the English court cannot make findings of foreign law that go beyond the present state of foreign law and anticipate rational developments of it. That was the point that was made in Superpat that we have relied on in our skeleton at paragraph 96.
But on the basis Brazil has a code, it's not really a rational development of Brazilian law, is it? It's an application of the existing law that has not yet come across that set of facts.
Well, my lord, I would not want to argue that it's a rational development. My point
I
is
just mean
simply
in the civilian code
yes,
development.
absolutely, but there's a larger point which goes back to the exchange that I had with the bench on this point about how significant it is that Professor Rosenberg said there was no impediment in thesis. In my respectful submission, the start and the end of the matter is that there's no STJ case that has done it.
Would that necessarily matter? The question for the judge, surely, is how would the Supreme Court of the foreign jurisdiction decide the point if it were to come before that Supreme Court?
Yes.
And the state of the evidence is, as I understand it, the point has never come before the Supreme Court. There are cases in which the point didn't arise because they were cases of vicarious liability. So what would happen in a case which is not a claim based on vicarious liability were that to come before the STJ? And that's Professor Rosenwald's view. He says, well, there's nothing to, that is what the STJ would decide.
Yes,
I mean,
but
that's perfectly good evidence, isn't it? It's not.
well, it's perfectly good evidence as to the future development of the
Or is it
Brazilian
the
law.
future development, or is it the ambit of Article 200?
Well, my lord, it's not just that it's not come up and hasn't been applied. The case law that was before the judge indicated that it had only been applied, and I emphasize this, we explained why that was so. And I've obviously not troubled this court with the detailed underlying explanation of why it is that Article 200 is limited to vicarious liability. But can I comfort the court with this, which is there were extensive submissions on our side of the courtroom explaining why it was that it was restricted to vicarious liability. So we did not accept and would not accept that that is something that Professor Rosenwald or indeed the claimants had developed so as to explain it. My lords will remember, this was only proffered in oral evidence. It was said in the way that I've just explained in response to cross-examination questions. That is not good enough, even for the, well, this might happen were a case to come. My lords, that is the parties' issue in Article 200. I'm going to try and do the CDC in the remaining time, which is ground 4. My lords, the CDC, I think there was a comment made about whether I'm dropping something. I understand that the court will appreciate that I'm not addressing every single point in every single ground. That does not mean that we are dropping any of them. I'm focusing on the points that I can, I hope, hopefully develop submissions on. So we are most definitely not dropping the dependency point, which is the second part to Article 200. But I think the court will appreciate that if BHP wins on the parties issue, then that's an end of the matter for Article 200, which is why I focused on it. So the CDC, the Consumer Defence Code. The critical issue here was whether the Consumer Defence Code required that harm be caused by the production of a consumer product. And I will call this the base consumer issue for shorthand. My lords, that issue was determinative because it was common ground between the parties that what Samarco produced, the iron ore pellets, was not a consumer product. So that was common ground on the facts. Could we start with our closing submissions at page 424? So this is N2 1.1 424. So, my lords, we identify the core issue between the parties in the first two paragraphs. The claimant's case, as you'll see there, is that a 5-year limitation period applies pursuant to Article 27 of the CDC because they said it was a consumer event. And that was based on Professor Rosenbaum's evidence where he said that the Consumer Code applies to any case where damages are claimed as a result of environmental accident. So that was his evidence. If it's an environmental accident, then the claimants can benefit from it. Our position is described in paragraph 1322. We submitted that the bystanders, and I'll come on to explain who they are, can only benefit from Article 27 if the event arises from a consumer relationship, that is a relationship between a supplier and the final consumer. And we then said in 1322.2, no consumer relationship exists in this case, and the claimants make no proper attempt to suggest how it could. To the extent that it's been suggested that a consumer relationship may exist where a party merely creates a raw material that may be eventually turned into a product, that proposition is contrary to Brazilian law. So that was the nature of the dispute. And if we go to 1323, we explain the written law, and we explain in particular, if we go over the page, why the consumer that is referred to in Article 12 can only have been a final use consumer. And so just stepping through those submissions, we start with the purpose of the CDC, which is the protection of consumers at 1323. 1324, we explain that Article 17 says, for the purposes of this section, all victims of the event are being consumers. Now, Article 17 was in a section which had essentially two substantive provisions, Articles 12 and 14. Article 12 dealt with where there was a defective product, and Article 14 where there was a defective service. And so if you were the person that was harmed by the defective product or service, you would claim under Articles 12 or 14. If you were a bystander, that is to say, not the person directly impacted, you could claim under Article 17. So that is the bystander, also referred to as consumer by equivalence in various different contexts. So the claimants had to show that they came within Article 17. That was the key issue. Could we go on to 1333 in our closing submissions, which is page 427. The heading is Need for a Consumer Relationship, the case law. And you can see there that we say, in accordance with the clear terms of the written law set out above, Brazilian courts have consistently held that a consumer relationship under Articles 12 or 14 is a necessary prerequisite the right to claim as a bystander under Article 17. So you have to have somebody who's already bought the product or had the service in order for you to come along under Article 17. And we then refer to the detailed analysis of cases that we've done in the annex, and we explain that we've split them by categories, and then we set out how we've approached them. So in terms of the reasoning, when it's been applied, when it's not been applied, we've explained all of that. And I want to show the court Annex 9 in a moment, but can I just finish with the submissions? So we set out, you will see over these pages, the analysis of the case law. And then if we can go to 1344, which is page 431, you will see that we address something called the supply chain issue, which was not advanced by the claimants in closing. And we then have a section where we address the application to the claimant's claims in 1349, which is at the bottom of page 432, and we say that the 5-year prescription period has no application to their claims because the mining of iron ore does not constitute any part of the supply chain by which the product is provided to a final consumer. And so we said that they couldn't come within it. That was the shape of the case that we advanced. Can I show you now Annex 9, which is N3, tab 4, page 17. This is 9B of that annex.
And in our supplementary
I
bundle.
think it's in your supplementals, and I hope somebody's going to be able to tell me the tab. 21.
21.
21 of your supplemental bundle, my
Yeah.
lord. I just want to introduce this document rather than go through it. You'll be pleased to know once you have a look at it. My lords, these are all the cases relied on by the experts.
Inevitably, it was the bundle I had open. I'm sorry.
That's quite all right. It's page 17, my lord, Annex 9B. I hope you have the same pagination, so it's N3417. Can I check that my lords have the document?
Yeah.
Thank you. So these are all the cases relied on by the experts, separated into fact categories. And you can see that from column 1. So if I just invite you to just cast your eye down the columns, you'll see, for example, there are tailings dam cases, gas leak, light poles, etc. And you'll see in the 5th column, the one that's headed consumer relationship, what was identified in those cases. So for example, none present, CDC therefore not applied, and so on. And I want to show you the light pole cases, which start on page 18. And those are relevant because the judge relied on 2 categories of cases. She relied on hydroelectric, power cases, and poultry. And the light pole ones are relevant to the hydroelectric. So the light pole cases on page 18, the court will see from column 1 that these are cases concerning pollution caused by chemicals used in the production of electricity poles for an electricity company. And could I ask you just to look at that first entry in column 5 on the consumer relationship? You can see that Justice Severino explains why the claim is a consumer accident as follows. The light posts are a fundamental input for the distribution of electricity to its consumers. If the injury suffered by the end user was a shock caused by an electrical discharge, there would be no doubt about the occurrence of CDC. So the reason the CDC applied was because the damage flowed from the production of a consumer product, that is electricity. Could we then go on to page 20, where you will see the poultry cases, and these concern environmental damage caused by a poultry farm. And in these cases, the consumer product is obviously poultry, as you can see from column 5. And then finally, we've addressed the hydroelectric power cases at page 21. And again, if we have a look at that, you will see that the consumer product there was again electricity. So the court can see that this base consumer issue that divided the parties, and you've seen, I hope, a flavour of our submissions on that issue, and that is what the court was required to address. Could we now turn up paragraph 926 of the judgment, where you will see the framing of the issue by the court. It's page 190 of the judgment. Now, my lords, this is the only passage in which the judge addresses how the written law applies to the base consumer issue. And so the first sentence finds that it is clear that a consumer relationship is required on the written law. Pausing there, the court will recollect from what I have shown you that the consumer relationship that's needed is between a supplier and a final use consumer. And if that relationship does exist, then a person who is not the final use consumer can qualify under Article 17 as a bystander. But then if you look at the second sentence, that suggests that there is some interpretation of the written law that does not require a final use consumer. But the judge doesn't identify which terms of the written law she considers are being interpreted, or how those terms might be extended to all victims of environmental accidents. And the court can see that the judge does not engage at all with our analysis of the written law. As I've shown the court, our submissions made it absolutely clear that unless the consumer relationship needed by Articles 12 and 14, and therefore by Article 17, it needs to exist before you can rely as a bystander under Article 17. So then the judge goes on, you will see, to cite passages from 5 cases, and that's from 927 onwards. And she gives a conclusion at 935. I just want to make 3 points on all of the 5 cases that she refers to. First, the relevant consumer product was clear in all of these cases. So as I've said, in the poultry cases, it was chickens, and in the hydroelectric power cases, it was electricity. Second, the passages from the cases that the judge sets out in the judgment, the court will see, but if you have a look through them, if you just scroll down, you will see that there's no or minimal commentary from the judge. So it's very difficult to understand what, if any, reasoning is involved. But again, there doesn't seem to be any engagement with our submissions in our closing or in Annex 9. And third, and crucially, all of the passages cited by the judge clearly refer to the need for a consumer product. Therefore, they support BHP's case and are contrary to the conclusion that the judge actually reached. Can we then look at that conclusion in paragraph 935? That's page 194. So, my lords, that first sentence, what emerges from the recent line of authority is that the STJ has adopted a broad interpretation of consumers to include individuals indirectly affected by the exercise of a polluting business activity. That does not engage with the base consumer dispute, which is, as I've shown you, the dispute as to whether the polluting business activity concerned the production of consumer products. And then the second sentence, relevant damage is not just that caused by the product itself, but is capable of extending to damage resulting from the production process. My lords, this statement is entirely irrelevant to the dispute between the parties. It is not clear what the judge means, but she may have formed the view that Samarco was part of the production process of a consumer product. But as I've explained, the claimants did not allege in their closings that Samarco was part of the production process of a consumer product. That wasn't an argument that they were running. So if the judge made this mistake, then she misunderstood the dispute between the parties. And then if we look at the third sentence, just the first part of it, she says, it matters not that the processing of iron ore pellets, which requires the storage of iron ore tailings, does not give rise to any direct consumer relationship with the claimant. my lords, that phrase "with the claimants" is again indicative of a fundamental misunderstanding of the dispute. That the court will recall, as I said, the claimants were relying on Article 17. So by definition, they were not the ones that had the relationship with the supplier of the product or the surface of the service. And so if there was such a relationship, then Articles 12 or 14 would be engaged, and the claimants wouldn't need to use Article 17. So, my lords, she has evidently misunderstood this because of the fact that she's talking about the relationship between Samarco and the claimants. Had there been that direct relationship, the claimants would have relied on 12 or 14. It's the fact that there wasn't that direct relationship that they had to rely on 17. But their case was that you don't need the consumer relationship at all. All you need is the environmental accident. But none of that is addressed in this passage. So again, it suggests that she has misunderstood the issue. And then the last part of this sentence, she says it is sufficient that it is a business activity intended to produce a product with the potential to cause environmental impact for the collapse of the dam to be characterized as a consumer accident. The meaning of this is unclear. It's consistent with our case if the phrase, the product, is a consumer product. That was the matter in issue, but it's unresolved. Now, if the judge is saying that the CDC required the production of a product, but it didn't need to be a consumer product, then that's not a finding that was being advanced by either party, and it's also irreconcilable with the written law and not supported by any of the case law. So, my lords, we say that standing back, the judge failed to engage with what we identified as the critical issue, that is the base consumer dispute. The single paragraph of reasoning that we have is this paragraph 935. It leaves the issue of the nature of the product and the business activity that she has identified unresolved. And to the extent that the judge did engage with that issue, we submit that she seems to have clearly misunderstood the written law and the relevant case law. Could I also, because I'm conscious that I've gone through that very quickly, just say that we have given you the full version of the CDC. It's quite short, and as reluctant as I am to suggest that the court might want to do any additional reading, it is something which, if you can read Articles 2, 12, 14 and 17, I would be very grateful. My lords, it's I1 20T1. Just before I finish on the CDC, could I deal with the point that the claimants have raised in their skeleton? So their sole response on this point is to rely on the Mariana case. The court will have seen that. They say there is one case, it answers it all, and they rely on it. Can I first of all just show you where this is referred to in the judgment? It's in 934. So it's still on the screen, and the court will see that after the judge has set out those cases that I described, and those run to 933, she then says a similar approach was taken by the STJ in further cases. My lords will see that there's a string citation of several cases, and you will see Mariana at the end of that list. So that is where the judge puts that case. That case was identified, as the claimants have explained, only after the expert evidence had closed, so it wasn't put to the experts, and we nevertheless addressed it in our written closings and then addressed it further in oral submissions. Can I just quickly show you our written closings on this? It's one paragraph. It's paragraph 1343, which is N2 1.1431. And you will see that we describe the case, and then we say halfway through, in any event, the decision does not change the analysis, and BHP are accordingly content to address it in submissions.
I'm sorry, you said paragraph 1343,
My lord, yes.
starting by letter dated.
Yes, my lord.
Right.
And I just invite to note that we have set out there our submissions on why the case does not change the analysis.
Yeah.
There was a single statement that was made, and we explain why it doesn't advance things. I then made quite extensive oral submissions on this point. And I just want to give you the reference, which is L2 48, 43. I'm just going to tell you what my 4 submissions were rather than take you to the transcript, if that's all right. The first point I made was that this appeal concerned the reversal of the burden of proof, not limitation. And it was a crucial point because the reversal of the burden of proof is subject to a binding precedent. And so the case is absolutely not as it's been presented by the claimants in their skeleton. They say it is indistinguishable from the present proceedings, that's 59. They say it is precisely on point, that's paragraph 60. It was not. It was about the reversal of the burden of proof. The second point is it was those other provisions on the burden of proof that were the basis for the dismissal of the appeal. The third is, as we said in our written closing, there was a single line conclusion in that case which the claimants relied on, but it did not suggest that the court was rejecting the requirement for the base consumer relationship. And fourth, we said, whatever the passage did mean, very little weight could be given to it because it was obiter, one sentence, and it doesn't make any reference to the fact that the question of the application of the CDC to limitation was, as I'm sure this court is aware, in the process of being decided by the STJ. So we said, this doesn't help. But can I now go back to 934 and show you again how the judge dealt with it? And there are really 2 points here. We say the judge is plainly not relying on Mariana for her conclusion. That is obvious with respect, given the way that she has referred to it. And if the claimants are saying in their skeleton that that is what she has done, then that is plainly wrong because she says nothing of the sort. And second, if the claimants are right, and in fact, what we're supposed to get from this reference to Mariana is that the judge based her entire distinct decision on the direct application of this single case, then that, we say, even more strongly supports our appeal, because you can see there is no reasoning whatsoever. The 4 points that I made in oral submissions, the point that I've showed you in our written submissions, has not been engaged with. So if the claimants are right, and that is what she did, and that is how she treated it, then it makes our point even stronger on failure to engage. So, my lords, I'm 2 minutes over. I'm very sorry, but we rely for the remainder of the submissions on the skeleton.
Yes, thank you very much.
May I start with a couple of corrections that I wish to make to our skeleton, just for the sake of completeness. The first is in paragraph 26, line 3, the words the evidence of are missing before a BHP employee. I suspect you've probably worked that out already.
Yep.
Second is there is a missing reference in our skeleton at the end of paragraph 33. And the reference there should be J/349, first 2 sentences. So that's paragraph 349 of the judgment, the first 2 sentences. Turning to the application itself, I'm going to deal with the proposed grounds of appeal in relation to strict liability and fault-based liability, and Mr. Fulton will address you in relation to limitation. before I delve into the detail of the proposed grounds, can I start with some overarching points which, in my submission, although no doubt well in mind, must be emphasized, because the danger, of course, in delving into the amount of detail that we are, is that we lose sight of what it is that has to be demonstrated on an application of this nature. And I just want to make 6 very short points. First, the judge properly directed herself as to the principles that the court must apply when assessing evidence of foreign law, here Brazilian law. See paragraph 235 of the judgment, page 44. In particular, she cited the Privy Council's summary of principles in relation, in Perry and Lopag, in relation to the receipt of foreign law evidence. Secondly, the Brazilian environmental law is a special body of law within a civil law system, and that's clear from paragraphs 237 and 253 to 259 of the judgment, pages 46 and 49. Hence, the judge's findings as to the applicable legal tests for a polluter and in relation to causation under environmental law are clearly at the very far end of the spectrum of familiarity for an English judge. And on this application, therefore, BHP must demonstrate a realistically arguable case that the judge reached conclusions that no reasonable judge could have reached, or that were not rationally supportable on the totality of the evidence before her. Thirdly, insofar as the judge preferred the evidence of Professor Sarlet on behalf of the claimants to that of Professor Dantas on behalf of BHP, she did so with the benefit of having seen and heard them over 7 days of oral evidence, a critical advantage that simply cannot be replicated on appeal, let alone on this application.
Or on a retrial on the transcript.
Or indeed a retrial which merely involves reading a transcript. Fourthly, her findings as to the applicable polluter and causation tests under the environmental law were arrived at not merely in reliance upon consideration of the expert's evidence, but taking account also of the interpretation and application of the environmental law by numerous decisions of the STJ. You see that, for example, in relation to the concept of the polluter at paragraph 322 of the judgment, page 78, and paragraph 352 in relation to the causation test on page 85. Fifthly, when it comes to the application of Brazilian law as found by the judge to the facts of the case, BHP's strategy has been to island hop to those bits of the evidence that it likes and to ignore the evidence that supports the judge's findings. We have tried to identify some elements of that evidence in our skeleton, but even that, short of actually going to the 500 pages of written submissions that both sides filed at trial, even that is only a snapshot or a selection of some of the key evidence. So the point about the judge being uniquely immersed in a sea of evidence is properly made in this case. But the key point when it comes to it, we say, is that there's no realistically arguable case for contending that the judge has ignored any relevant evidence or failed to engage sufficiently with the key arguments that were being advanced by BHP. And sixthly, and finally, that's an overarching point, we say that much of BHP's attack in the context of fault-based liability focuses on the alleged effect of a few isolated factual aspects that they have chosen to make the subject of their complaint, but without regard to the fact that the precise weight to be attached to such isolated facts was quintessentially a matter for the judge in her assessment of fault in the light of all of the circumstances of the case. And what we say BHP has needs to show, but has failed to show, is a realistically arguable case of an irrational conclusion on the facts or a material error of principle in the evaluation of the very complicated factual and technical matrix that was before the judge. So with those general points out of the way, can I turn to the detail? And the way in which I propose to deal with the detail of the arguments you've heard in relation to the grounds themselves, I will resist repeating what's in my skeleton. I will take my skeleton as read, and if I may, I will focus on those particular points that the other side have made orally that I feel I ought to respond to. But in a couple of instances, because they link up with my oral response, I will emphasize some of the points that I've already made and perhaps take your lordships to some of the underlying material that perhaps you've either not looked at yet or have only had limited time to look at. So I think on my numbering I have 29 points, but hopefully 29 points that I'll be able to cover on average by in about 2 minutes to keep to my hour or so. Can I start with my first point, which relates to the question whether the judge departed from agreed expert evidence in relation to two distinct concepts of polluter, namely direct polluter and indirect polluter. You've seen what we've said in our skeleton about how that very issue was raised by BHP at trial and was the subject of submissions. They said to the judge, the experts are agreed that there are two distinct concepts of direct polluter and indirect polluter, and they built their case on that proposition. You have the material that shows, in my respectful submission, that certainly Professor Salad did not agree that there were two legally distinct concepts of polluter in the way suggested. What my learned friend did earlier in her submissions, orally, is to now suggest that all that she was putting to Professor Salad was that there was a factual distinction between a direct polluter and an indirect polluter, and nothing more than that. But of course, the reason why they have always framed the debate about the polluter definition in this way on BHP's side is because their case is there are two very distinct categories, each subject to its own distinct and very narrow legal requirements. Direct polluter has to be the operator, indirect has to owe and breach a duty of safety. There ain't anything in between. That was their entire case. And what you find in the transcripts of evidence that we've shown you from Professor Salet's oral evidence is that he accepts there is obviously a factual difference between direct responsibility and indirect responsibility. One doesn't have to cross-examine to establish that. That wasn't really their aim in cross-examining along those lines. They wanted to establish that there was distinctness legally. And what Professor Salet made very clear in his answers was there is of course a distinction as a matter of fact in terms of degree of proximity between the defendant or its conduct and the relevant activity or the damage. But what he was making very clear is that the law recognizes a single concept of polluter, whether directly or indirectly responsible for the activity. And so that is what you see in the evidence. And in my respectful submission, that is very clear. But the point goes further than that, because what Ms. Fatima says is, well, look, this is all very complicated. All you need to decide now is that it's complicated and therefore it ought to go off to the Court of Appeal. So you don't even have to grapple with it, namely the question whether there was a concession in the form that she alleges there was. But that's not the real question for you on this application. The real question for you on this application is whether BHP has demonstrated a realistically arguable case that the judge's treatment of Professor Salet's evidence, and in particular, her interpretation of whether his evidence was, as BHP suggests, in the nature of a concession, or as she has found, and that you've seen already at paragraph 295 of her judgment, is evidence to opposite effect to that which was being given by Professor Dantas. That's the question. Can they show realistically that the judge's treatment of that point, and in particular her interpretation of the evidence, was simply irrational. And in my respectful submission, they can't come anywhere close to that. And indeed, one might say that the very fact that when your lordships look at it, I would respectfully suggest, prima facie are puzzled by the suggestion that this was a concession. That of itself is sufficient material, I would respectfully suggest, for the trial judge who will have had the benefit of much longer reflection on the point to say, well, I find, as I do in paragraph 295, i.e. that Professor Sarlet did not accept that case. And so we said that is really the key point, and that's the short answer to that particular complaint. The second instance of allegedly agreed evidence that they say existed as between the experts relates to the question of who may be a direct polluter. We've already addressed that at paragraphs 12 and 13 of our skeleton, and again, I've drawn attention to the relevant sections of our corrections table that address that point. But one important point that I ask you to bear in mind, that what BHP suggest was agreed between Professor Sarlet and Professor Dantas was not even agreed vis-a-vis Professor Dantas on his oral evidence. In particular, his own oral evidence, as the judge recorded at paragraph 318 of his judgment, and again, because of shortness of time, I won't take you to it.
I think her judgment.
Yes, of her judgment, exactly. She records her finding that Professor Dantas had expressly accepted during his oral evidence that direct responsibility could also be established by virtue of participation in the polluting activity. In other words, it's not limited to the operator, stricto sensu, of the activity, or in the case of mining, the license holder. And that is an aspect of Professor Dantas's own evidence for BHP that BHP entirely ignore in putting forward their theory of agreed expert evidence in relation to who a direct polluter can be. The third instance of alleged agreed expert evidence relates to whether there can only be an indirect polluter where the person in question owes and breaches a duty of safety. And I think the only point I need to draw to your attention in relation to that is in response to my learned friend's submission that the judge's conclusion at paragraph 328 of her judgment that there is no need for a duty of safety for there to be indirect responsibility, although a duty of safety and breach of it may be a ground for imputing indirect responsibility, but it's not the only ground. They say, well, that reasoning was completely, or that conclusion was wholly unreasoned. That is simply not correct. And that's not correct because the court, the judge, set out at some length in her judgment the mangroves line of authority that contained the famous dictum by Justice Herman Benjamin as to what would suffice or what may suffice to satisfy the causal chain of responsibility under environmental law. And it's the point that we make in paragraph 14. If you pick it up at the top of page 6 of our skeleton, you can see that we refer to where the judge quotes from the Mangroves case, which is at paragraph 297 of her judgment, and also paragraph 298, where she refers to a slightly later STJ decision that follows Mangroves, the Jacupiranga decision. And in both of those, we have quoted in footnote 6 what we call the Benjamin statement and what was referred to at trial as the Benjamin statement. And if you look at the Benjamin statement, what you see there, self-evidently, is a list of categories of conduct, of which doing the activity is one of them. The second is those who don't do it when they should. In other words, what the parties referred to at trial as the omissive behavior category, which is a form of responsibility as well. But other forms of conduct, those who don't mind it if they do it, those who finance it and those who benefit when others do it, as well as in the Jacobiranga formulation, those who do not mind if they do, or those who are silent when it is within their competence to report. And so, for example, what you see in the SCJ case law is, for instance, landowners who allow their land to be contaminated and don't do anything about it. They are responsible just as the actual polluter or the person who may have been responsible in the first place for the pollution. So it was a whole range of conduct that's encompassed by the Benjamin Statement. And that all occurred in the context, if we look at paragraph 298 on page 62 of the judgment, where the Benjamin Statement appears in Jacobiranga, what you see there is that formulation of responsibility and causality under environmental law is expressed in terms of the concept. If you look at the bottom of page 62, if we go to page 61, please, we can see that that's just situate the case. This is where the judge, after referring to mangroves and having cited the Benjamin Statement in the paragraph, in the quotation just above paragraph 298, then goes on to say, Justice Benjamin restated this broad concept of polluter in Jacobiranga. And if we go to the next page, at the bottom of page 62, you can see that in Jacobiranga, Justice Benjamin goes on to say, the concept of polluter in Brazilian environmental law is extremely broad, and it is intertwined by express legal provision with the concept of degrader of the environmental quality. That is all and any individual or legal entity, whether governed by public or private law, that is liable, and then emphasis, directly or indirectly, for an activity that is causative of environmental damage. So that was the context in which the judge analyzed the question whether, as BHP submitted, a duty of safety was an essential requirement of indirect polluter liability. And she said, in the light of her analysis of that case law, that it wasn't. So the idea, therefore, that that conclusion was wholly unreasoned is simply not correct. And I've given all the references to her judgment where she analyzes the significance of the Mangroves Land Authority and the Benjamin Statement. But what is more, as she also recorded at paragraphs 309 and 310 of the judgment, that's starting on page 74, Professor Dantas himself, for BHP, accepted in cross-examination that the Benjamin Statement was a correct statement of the regime of environmental civil liability in respect of both direct and indirect polluters. And further still, she noted, again correctly in the light of the evidence, that in his own academic writings, Professor Dantas had relied on the Benjamin Statement to describe a polluter as someone who somehow contributes to the degradation of environmental quality with a causal link between their conduct, whether by commission or omission, and the damage being established. And he stated that the polluter can be any person as long as they can somehow be related to the environmental damage resulting from the conduct. And nowhere in his own writings did he ever suggest that the existence and breach of a specific legal duty of safety was essential to give rise to indirect polluter liability. That was also evidence that the judge heard and took into account. But of course, the other side totally ignore it. And if your lordships need the reference, I have also given in footnote 8 the reference for the actual quotations from Professor Dantas's own books. There were two books, or two publications in 2021, obviously before he was retained by BHP to act as expert in the case. But nevertheless, we submitted a trial more reflective of the true state of affairs than the evidence that he gave at trial. And the judge accepted that because she relied on his academic writings as being part of the evidence. So that, I think, deals with the first 3 points.
Is that your first 3 of 29?
No, in fact, on my numbering, I'm on point 6. So I think I'm making slightly faster progress than my numbering might suggest. And I hope I will accelerate too. There's a further point as well that I ask you to note, which is this. The judge also referred at paragraph 304 of her judgment, and that's page 70, to the different hypotheses of indirect responsibility that were recognized in the vicuña. If we perhaps can have a brief look at that, page 70 of the judgment, paragraph 304. So this was this was one of the most recent. This was the 10-member panel of the STJ in the vicuña, if we go to go further down, please. Thank you. If you look at the penultimate paragraph, this is because since the buyers of the cargo of the aforementioned ship are not directly responsible for the accident, they could only be held liable as indirectly responsible for the environmental damage if it were demonstrated, 1, the existence of omissive behavior on their part. That's the omissive behavior category where you owe a legal duty but you omit to do something. So that's one potential basis for indirect responsibility. But the panel went on to identify at least 2 other potential bases of indirect responsibility in the factual scenario they were faced with. Namely, if the risk of accidents in maritime transport was inherent to the buyer's activity, or if it was their responsibility and not the selling company's to hire the transport for the cargo that was destined for them. So in other words, it's the clearest example of the STJ saying indirect responsibility does not merely arise by reason of failure to act when you owe a duty to act and you fail to act in accordance with that duty, but it might also include other circumstances which, by reason of the connection that they disclose between you and the risk created by the activity, might justify your being made responsible or being held to be indirectly responsible for the activity.
Such as hiring the ship.
Such as hiring a ship if the accident happens during the maritime transport. Even though all you've done is to hire the ship. You don't run the ship, you don't do anything else, you just hire the ship. And the reason why the buyers in that case were not liable is because it was the sellers who had organized the freight. And in fact, in that case itself, although I don't think that particular passage is quoted in the judgment, one of the things the STJ also said was the seller would be liable as an indirectly responsible polluter. Although it's the same situation as they are positing in Roman 3 in this particular passage, where they posit that if the buyer had been responsible for the transport, then they would be held to be indirectly responsible for the activity. So again, this is the problem when you island hop in relation to foreign law evidence. I hope this gives a better reflection of the sea of evidence that the judge had before her. Can I turn to the 4th line of argument that BHP has under ground 1.1, which is that the judge should have rejected the multifactorial approach in the light of the experts' evidence in the case law? Well, I've already given you the highlights in terms of how the judge relied on the Mangroves line of authority and the Benjamin statement, and how even the vicuña, a case that the other side relied upon very heavily, supports the same broad approach to the concept of polluter. And I don't think that I need to go over that again. But 2 points that I emphasize again for your note. First, the one that we make at the end of paragraph 18.1 on page 8 of our skeleton, which is the judge's reference, paragraph 326 of a judgment, to the Federal Justice Council's express reference in a formally approved statement at a national legal conference in Brazil to the multifactorial causal chain in the context of the broad concept of polluter. That's in the context where statements such as these are regarded by Brazilian superior courts as a particularly valuable doctrinal source. So insofar as it is said that, well, the language of multifactorial approach does not specifically appear in any STJ case, certainly the legal community, the environmental legal community at large, does not appear to have any difficulty with that characterization. And I also ask you to bear in mind the judge's finding as to Professor Dantas's evidence at paragraph 326, which we refer to at paragraph 18.2 of our skeleton, where the judge pointed out that Professor Dantas, although he objected to the term multifactorial, agreed that responsibility under Article 3.4 could be based on a number of factors and arise in a variety of situations. Again, in our respectful submission, evidence that would have been entirely consistent with and supportive of the judge's overall conclusion. Can I therefore turn next to the second subground of appeal, which is on strict liability, which is the application of the law to the facts. Now, there was a debate between the bench and Ms. Fatima this morning as to the proper meaning to be attributed to the judge's formulation of the test at paragraph 449 of her judgment. Our reading of paragraph 449 is that the judge was focusing on the exercise of controlling shareholder power over the relevant subsidiary or underlying company. She was not suggesting that the shareholders themselves had to have taken the underlying business decisions and undertaken the underlying operations. In other words, she wasn't suggesting, as it were, that the shareholders should have usurped the role of the subsidiary's employees and got into the driving seat in that way. We say that's self-evident from that passage. But in any event, if there were any doubt as to how that passage should be construed, I invite you to take into account the facts that she considered to be relevant to her application of that test, because it's very clear from the facts that she took into account that she intended the test in the way that we've interpreted it, and in the way in which your lordships, at least prima facie, appear to have interpreted it. They did not interpret it in a more, she did not mean it in the more radical way that I think BHP put it at paragraph 34 of their skeleton, which is that the judge needed to determine who in fact was making Samarco's detailed business decisions and running its operations. That is misstating the test in our respectful submission. Once you get over that point, then in my respectful submission, what is very clear from the rest of the material that we've drawn attention to is that, of course, if the relevant inquiry is as to the exercise of controlling shareholder power in relation to the underlying operations of the company below, of course you have to take into account the levers of control, if I can put it that way. The constitutional and corporate levers of control and influence. And of course, you then also need to take into account as to how those levers have actually been operated. Now, you will have noticed, and I don't think it can really be a serious point, the other side say that because the judge has found that the mere exercise of controlling shareholder power is not of itself sufficient to engage responsibility. Therefore, it was irrelevant for her to have taken into account the framework, the control framework that existed between BHP and Samarco. But that is obviously nonsensical. She needed to have carried out that exercise in order to understand and satisfy herself that there was such a framework in place to start with. But the key point is that she obviously did not limit her analysis to the existence of the framework. She then went on to consider how that framework was actually implemented in order to allow BHP to effectively deploy the power that it had. We've given the relevant references in paragraph 24 of our skeleton, and I don't think I need to go over that again. But I just want to give you two very small examples, because I'm trying to think of the simplest way of trying to convey the massive involvement that BHP had in Samarco, that you know very little about, because admittedly the judge dealt with that point over a number of pages, but relatively briefly. And one of the paragraphs that I think, one of the points that she makes, someone will tell me what the paragraph is where she makes the point, it's very clear from the contemporaneous documents that BHP was involved and had control and influence over all levels of operations within Samarco, from the strategic to the operational. To give you a sense of what the contemporaneous documents show, we've drawn attention to a summary that we prepared, which I think is in the supplemental bundle at tab 16, of just a number of topics that were regularly considered at the various Samarco board and multiple committee and subcommittee meetings, as well as working group meetings. If we have a look at that briefly.
Just before you do that, you gave us a sort of tantalising suggestion about the paragraph number.
Yes, it's 454.
It's not 802 then, it's 454.
That's what I had in mind.
There is some in 802.
It may be that 802 is something quite similar to it.
454.
It's 454, page 100. 453. Oh, I'm so sorry. No, it's not. Sorry. Let me forgive me. Let me just find it myself.
453.
Can't see 453. Yes. Yes. It's sorry. I had in mind 450, where it actually refers to the contemporaneous documents. But there's then a relatively brief summary by the judge. But to give you an example, if you look at if we look at SB 16, which is N1, tab 1.4, page 1. If we look, which is at SB 16, tab 16 of the supplemental bundle.
You gave us
yes, you have an A3 copy, which
we can actually read.
Which you can hopefully read, although perhaps with some difficulty, because it's still quite.
Version that's half the size.
And I just want to just flick through very briefly. You can see, if you look, for instance, on page 2, if we look, let's say at the top of page 2, you can see it starts with November 2009. In fact, let's just go straight to page. Forgive me. Let's go to page 13, because that's.
What is this showing?
What it shows is.
Is it the case?
It shows the sheer number.
These are BHP people on these committees.
Exactly. So on the board there are 4 BHP representatives and 4 Vale representatives. On the committees, there would typically be 2 or 3 BHP representatives and 2 or 3 Vale representatives. At times it could be a lower number, it could be 1 or 2. But again, it's BHP and Vale representation, and then some Samarco representatives as well on the committees and the subcommittees.
And BHP was entitled to have those representatives because of the shareholder agreement.
But, absolutely, because because together with Vale it controlled the board, and those committees existed effectively to assist the board, but also to allow BHP's interests and Vale's interests to be represented. Because and that's one of the points the judge made in relation to the joint venture nature of the company. The company was a vehicle whereby effectively BHP and Vale would achieve their objectives, and that being the overall setup, it was necessary that they were represented on all of those committees. And what you find in terms of the topics that are addressed by those committees and subcommittees and board and working groups is there's no limit to what can be discussed, and it straddles the strategic, the financial, the operational. There are issues about safety, there are issues about the dam. There's simply no limit. And of course, and at trial we had the detailed minutes for each of those meetings. And the judge, of course, wasn't taken to all of them, but she was taken to a number of them because they were used in cross-examination. So she was immersed in that minutiae in a manner that, yes, I accept, is not described in minute detail in the judgment. The judge could probably have written another 100 pages just describing in minute detail the multifarious forms in which the BHP's involvement, control and influence over Samarco took. She could have done, but she dealt with it rather more shortly. And what the other side have done is effectively to kind of pick some individual topics that they quite like the look of in terms of what they can say about those topics, and say to you, well, she's not really applied her own test to the facts properly. And that's really all I can do within the confines of the application. But it gives you an idea of the mass of information that existed in relation to the BHP involvement in Samarco, which is why the judge, for example, described or used the expression depth of involvement at paragraph 453 of her judgment. And then the other document that she specifically referred to was a deliverables type document whereby effectively BHP called the shots as to what it wanted Samarco to provide by way of information about its operations. And this is only a 2-pager, but it's also an A3 in A3 form. If you just cast your eyes through that document, you will see there was a whole range of work product that Samarco had to provide to BHP on a monthly basis, ostensibly to allow BHP to monitor very carefully all of those aspects, and obviously ultimately allow its board and committee and subcommittee representatives to exercise their leverage and their control and their influence as they wished, and in a manner that they considered advance their interests. And one of the points that we make it is the point that the judge concluded in the light of one of Samarco's own documents, that, and we summarize that in paragraph 25 of our skeleton, namely that the executive board was subservient to the Samarco board. And that was what the judge found, and there was plenty of evidence for her to make that finding. One of which was, for instance, the fact that the BHP and Vale sacked the head of the executive board, the Samarco CEO, and that's referred to in paragraph 443 of the judgment at page 98, because he wasn't performing to their liking. So we do say, therefore, that the attempt to suggest that the judge somehow mischaracterized or misjudged what the documents showed or what the facts showed as regards when it comes to the application of the multifactorial approach is very wide of the mark. In relation to, in terms of the island hopping that my learned friend did, one of the little islands she hopped onto was the P4P project. And she made a number of points about that. We deal with that at paragraph 28 of our skeleton. The P4P project was one of a number of projects, and the projects were one of a very wide number of forms of involvement and influence on the part of BHP into Samarco. So even that particular snippet that my learned friend focused on is a big distortion of the entire picture. But even in relation to P4P, if you look at the judgment at paragraphs forgive me, at paragraphs 446, Roman 1 and 500 onwards, and if you look at our skeleton, our closing written submissions, at paragraphs 350 and 358 to 372, which are footnoted in footnote 15, you will see that there was a huge amount of involvement on the part of BHP in the initial assessment of the feasibility and viability of the P4P project, the financial, and by that I mean financial viability and feasibility, technical viability and feasibility. Huge amount of work done by BHP internally before it even becomes relevant for Samarco to consider it. And then in addition to that, as the judgment explains, and as we've covered in our skeleton, when it came to the approval of the project in a more formal way, that approval process involved multiple layers of approval within BHP before it even got to Samarco. And the witnesses were very clear, and the judge refers to that. If BHP had not agreed to the project being done, it wouldn't have been done. Not least because it's BHP representatives on the Samarco board and Vale representatives on the Samarco board. So unless BHP and Vale wanted it, it wouldn't have happened. And again, that's absolutely plain. So the attempt by the other side to suggest that BHP had effectively wholly inconsequential involvement in the pursuit of those growth projects is utterly unrealistic, and struck the judge as being so, which is why she ended up concluding as she did. And one further point in relation to this: it's not a case, as Ms. Fatima appeared to imply, of, as it were, comparing the number of staff or the volume of activity on the part of Samarco on the one hand and on the part of BHP on the other, in order to determine the question of the proper application of the multifactorial approach. The multifactorial approach in relation to BHP requires consideration of BHP's role and how it deployed its power in relation to Samarco, and whether that deployment justifies the conclusion that it was indirectly responsible for the activity. It's not a quantitative, it's not a basic or simplistic quantitative comparison between the amount of work done in the way that the other side are suggesting, which is why the judge didn't have to spend time analyzing each and every aspect in which Samarco was running the project. It was irrelevant. It was sufficient that BHP had been involved all the way through, had engineered the need for it, had pushed for it, had approved it, had financed it, and had implemented it at Samarco board level when it came to it. And moreover, BHP remained involved in its implementation in the ways in which the judge has already described through the P4P steering committee and through the insertion of a number of key managers high up within the project team. And again, that's covered in the judgment. So we say that it's really quite hopeless to try to minimize BHP's role in that way, or to suggest that the key analysis is what Samarco were doing. Causation, which is the final topic that I should address on strict liability. The first point we emphasize is that the judge expressly considered the issue of the need for causality between the defendant's conduct and the damage. And we address that in some detail in paragraph 31 of our skeleton. So we don't accept the proposition that she was oblivious to that point. She did consider it, but she considered it through the competing evidence that the two experts gave, with Professor Sarlett on the one hand saying that the way in which causation generally is approached under the environmental law is by means of effectively a two-stage process of consideration of whether there are enough factors to impute responsibility, direct or indirect, to the relevant defendant for the activity, and to consider whether the activity caused the damage. And if those two elements are present, then the test of causation under environmental law is satisfied. And that ultimately is the test that the judge accepted. And in our submission, it's not right, therefore, that she did not consider the issue. And insofar as she preferred Professor Sarlett's evidence, that was a conclusion that we say was eminently open to her, and it's not really been demonstrated how her conclusion is irrational or indeed, if that's being suggested, procedurally irregular. So that's what we say about that. Can I therefore turn to fault-based liability?
You only need to do that if you fail on strict liability.
Well, I don't think I do, and I don't think I do because the only grounds that are advanced by the other side for fault-based liability are alleged procedural irregularities, which they say are productive of injustice. That's how they put it. If, however, they don't get permission to appeal in relation to strict liability, which of course is the stricter regime, including as regards causation, if they don't get permission to appeal in relation to strict liability, it's very difficult to see at the moment how such procedural irregularities they may be able to show they've got a realistically arguable case about are productive of injustice as regards liability. That's very difficult to see, and they've certainly not tried to articulate such a case, and I think they have fairly accepted in their opening paragraph, one of their opening paragraphs in their skeleton, that they have to effectively get permission on both.
Yeah.
So I do make that point, but I don't rest on that, because we do say we've got answers to their points in relation to fault-based liability. So perhaps I can try and cover those. I think on my numbering it's 8 points. So let me try and rattle through those as fast as I can. The first point is this, and that concerns the ITRB reports and the suggestion that the judge wrongly failed to take account of positive statements in those reports and only focused on what you might say were the negative comments about the problems that existed. Now, the first point to note about that, and I've given the detail in paragraph 39 of my skeleton, so I didn't need to go through that, but I asked you to go through that carefully in your own time. The first point to make about that complaint is that the very positive comments that the other side say the judge has ignored are referred to by the judge later in the judgment. And I've quoted in paragraph 39 at least 2 examples of those arising from the January 2014 report and the July 2014 report, where the judge refers to the fact that the ITRB had commented on satisfactory stability, and in at least 2 instances. The second point is this. What the judge was doing in that part of the judgment was she was identifying the signs that should have been apparent to BHP of potential problems. She never suggested, she nowhere suggests in the judgment where she deals with those reports that found their way to BHP, because those are the reports that did find their way to BHP. We'll come later to those that didn't in a moment. But those that did find their way to the BHP, all she was saying in the judgment was, well, there were a number of warnings in there. Not of the dam about to collapse there and then, but about issues that, when you understand the geotechnical framework in which this dam operated, were important issues to bear in mind and to keep an eye on and to monitor. That's all she was saying. So she identified a number of ITRB reports as a source of information to BHP about drainage deficiencies. That was one of the potential important factors that might influence the stability of the dam. That's all she was doing. But she recognized that the report also had a number of positive comments. But the fact that there are positive comments in the report don't negate the fact that there are also that there were also observations about the drainage deficiencies. And one of the points that you will have noticed BHP has not made is that the judge was wrong in identifying the comments which she did identify as having been made in those reports about drainage, for example, and other matters. So
she had to determine the geotechnical causes of the collapse as well, didn't she?
Exactly. And you will note the judge, in a sense, worked backwards in her analysis in terms of how she structured her judgment. She analysed the causes of the collapse first. That's the first substantial part of a judgment. And once she had got that clear in her mind, you can see how she then considered that to effectively facilitate her analysis of the law, as well as her application of the law to the facts as regards both strict liability and fault-based liability. And one of the reasons, for example, why the other side say or suggest that the judge failed to consider counterfactuals in the context of causation is because they ignore completely her analysis of the geotechnical causes of the collapse. They simply look at the part of a report of a judgment that deals with fault and then the final bit on causation. They don't marry those two up with the geotechnical causes analysis that the judge had earlier carried out, which contain important findings that are not challenged and which provide critical background for analysis of both fault and causation ultimately. But let me try and move past my first point on the FB, fault-based liability. And the second point I want to make about that is that the question of the weight to be attached to negative comments, for example, that were in the ITRB reports, the question of the weight to be attached to those comments in the overall scheme of the evidence was obviously a matter for the judge, and not something that the Court of Appeal can really seek to reopen. On the question of the documents that were not seen by BHP, we have to be clear about the following distinction. At paragraph 45.2, I refer to documents that the judge quotes in paragraphs 748 to 792 of her judgment, which she nowhere refers as having been provided to BHP. So the thing that the other side accused her of doing, she does not record as having done in those paragraphs of her judgment. All she does in those paragraphs is to consider the objective foreseeability of the risk of liquefaction and hence collapse by reference to what was known at the time by a number of technically qualified individuals or entities. So if you look at that part of her judgment, she is nowhere there suggesting, and what's more, BHP had those documents and should therefore have known of those problems. She doesn't say that. In contrast to other parts of her judgment, for example, at paragraph 728 and 730, where she does make the point, Mr. Ferreira and Mr. Fernandez or this or that BHP employee were aware of and received the documents. So there was a clear distinction. And the reason she made that distinction is because in the part of her judgment that I refer to, paragraph 45.2, she was only addressing the issue of objective foreseeability of risk. So once you understand that, that particular part of BHP's line of attack really falls away. There was one point, however, that my learned friend made, which I accept is fair on the face of it, and that is in relation to the judge's statement at paragraph 803 on page 170, where she says, by August 2014, a number of things should have been known, and one of them is the August 2014 cracking incident. I accept that the evidence we have suggests that BHP only learnt of that through the November 2014 ITRB report. I accept that. There was no evidence that they knew of that cracking incident the moment it occurred. And so the judge in that sense slightly overstated the position. It would have been more correct to say by November 2014, the things that she describes in paragraph 803 were known or should have been known to BHP. But it doesn't matter, in my respectful submission, if she's made that small error in situating the point temporally, because the collapse we know happened in November 2015. Whether paragraph 803 says by August 2014 or by November 2014, that would not change. That would not have changed the overall conclusions as to either fault or causation. So we say that point doesn't really go anywhere. That then takes me to the pleading objection, which I think is probably the last point I need to deal with. I ask you to bear in mind that at paragraph 654 of the judgment, it's very clear that when she referred to legitimate concerns, having been raised. Sorry, could we please? Sorry, I've not got the. Thank you. Where she says legitimate concerns have been raised by BHP, that is a clear indication, my respectful submission, that she clearly addressed her mind to the pleading objections that BHP had raised. So there can't be a suggestion that she had overlooked the objections, point number one. Point number two, what's also clear from that passage is that she went through the pleadings with some care, because she says the material allegations considered below have been pleaded, but it must be said that at times the path through the pleadings to find them is somewhat tortuous. That is language that a judge will only use when they've actually endured the torture or tortuousness of the exercise.
Which happens often.
Which probably happens very often, no doubt not helped by the parties. But the serious point is that it was after having acknowledged and taken account of the objections, and after having gone through the pleadings herself, and she will have done that plainly with the benefit of the document that we refer to at paragraph 46, which is at tab 24 of the supplemental bundle, where we said in one colour of print, these have been pleaded, and the other side said no, they haven't for whatever reason, and we then replied, and the judge went away. It was a 20-page document or whatever with all the pleading references. The judge clearly addressed her mind to that document, in my respectful submission, and found it a tortuous exercise, but her conclusions nevertheless were as set out below. And so we say that there can't be any doubt that she's addressed her mind to it, and she has dealt with it in the way she has. I accept she's dealt with it briefly. and no doubt in an ideal world or in a different world, she might have dealt with it somewhat at greater length. But that's not to say that she's failed to engage with the pleading objections. And so we do say that those are important important points for your lordships to bear in mind. But there is a further point, which is this. Although BHP has alleged a failure by the judge to engage with the pleading objections, it hasn't actually sought to demonstrate that the judge's conclusion that the material allegations that she's identified have been pleaded is wrong. They haven't done that. They've not tried to demonstrate that where the judge identifies the 7, I think, allegations of fault, that they can demonstrate that these have not been sufficiently pleaded. All they've said is she's not dealt with, she's not addressed their objections. But the problem that this causes, their lack of engagement as to the detail and any attempt to demonstrate that those allegations have not in fact been pleaded, is that it's impossible to know whether even if their pleading objection were justified in the sense that, or rather, even if their complaint about failure to engage were justified, we don't know whether that is productive of any injustice. Because for all we know, these allegations have indeed been pleaded. They've just not engaged. They've just said, the judge didn't engage, we're not going to engage either, and that's enough. But that in my respectful submission is not enough. If you're relying on injustice as a basis for getting permission to appeal. Then the final point on that I do say is an important point, which is the third point that we identify in paragraph 46, which is that there are there were many other sources of knowledge that we identified there that were perfectly capable of supporting the judge's inferences as to what BHP knew or should have known, even apart from the topics that are the subject of pleading complaints. Now, my learned friend says, well, that doesn't really help you because I have other objections to your other sources of knowledge. Well, all right, that simply means that you're going to have to make up your mind at the end of the day, as it were, as to, well, which sources of knowledge really are subject to a reasonably arguable challenge or not, as the case may be. But certainly if all of our other points are accepted, then it would mean that this pleading objection effectively is of no real consequence. And then the final point I make on causation is my learned friend said that paragraph 807 of the judgment, which is the judge's conclusion on causation, contains no real analysis on causation. And we say that is simply not right when you follow through the judge's analysis of the geotechnical causes of the collapse, the foreseeability of the risk of collapse, BHP's fault, and then the judge's analysis of how a stability analysis would have revealed that the dam was not safe. The stability analysis is a particularly potent issue in this case. There were multiple sources of knowledge on the side of BHP that there should be a stability analysis dating back to 2012, which was never completed, despite substantial changes being made to the geometry of the dam through the setback that you will have heard about in the judgment. And what the judge has found is that that analysis should have been done, and it should have been done using certain parameters, undrained parameters, because the tailings were saturated, and therefore you shouldn't use drained parameters. And she relied on Professor Jens's evidence that a stability analysis would have revealed that the dam was unsafe. And that analysis was not disputed by the other side because Dr. Ma chose not to provide a rebuttal analysis in relation to stability.
Well, Mr. Tutor, you've had an hour and 10 minutes so far.
I'm so sorry, I should stop now. So my lord, I don't have anything further to say in relation to strict liability and full-based
I've got
liability.
one question for you, which is effectively by way of homework. Nobody's mentioned it yet, but there was a list of issues in this case.
Yes.
The version that's in the bundle, which is under tab 2 in the first of the 3 supplementary bundles, is marked up with various colours by way of pleading deletions, etc. After today, in other words this evening, can you just direct us, please, to where you say in the list of issues the allegedly unpleaded audit point would have appeared?
Yes. Thank you, my lord.
My lord, so I'll try and go quickly. Two general points in relation to limitation. The first of which is that a common theme of the judge's treatment of all 3 limitation issues was that she rooted her analysis in the STJ case law. She was obviously right to do so, as distinct from attempting to construe the written law for herself. That's a proposition which we cite Alarme and Shell for, Authorities Bundle 10. The second general point, particularly relevant to Article 200 and the CDC, is that the judge had careful regard to the prevailing trend of that STJ case law, placing greater weight on the cases which were more recent than the older ones, as being more reliable predictors of how the legal point would now be decided if it were to come before the foreign Supreme Court. And that's obviously the correct test, according to Perry. Article 200. Your Lordships know that the claimants had a very simple answer to BHP's limitation defence, which was that time wasn't running against them for the purposes of civil claims, whilst there were extant criminal investigations and prosecutions against a BHP senior employee. And accepting that analysis, the judge obviously drew heavily on what the STJ cases had said. I emphasise what they had said, because BHP are fond of saying, well, in some cases, there were, on the facts, convictions or confessions. And so that's consistent with their case about the need for some adverse outcome to provide the foundation. But no doubt, having regard to the need to show guidance to judges who followed, the STJ went to the trouble of explaining in the passages quoting by the judge that the outcome would have been the same so far as the applicability of Article 200 was concerned, regardless of the outcome in the criminal sphere. And I haven't got time to go through the passages, but from 848 to 854 of the judgment, there are repeated references to Article 200 operating regardless of the outcome. And those statements obviously go primarily to BHP's case on dependency, which Ms. Fatima didn't press. But they are also fundamental to the parties' point, as I'll come on to explain, because patently it is completely inconsistent with BHP's case if the operation of a rule which suspends limitation operates regardless of what ultimately happens in the criminal sphere. And those statements about regardless of the outcome focus on the end of the criminal process. There are also statements in the same section of the judgment dealing with the commencement of a criminal investigation as being the trigger which stops limitation time running. They're at 845, 846, 848 and 851, where it's explained that it's sufficient for there to have been merely a police investigation. And the reason why that is so important is that upon the commencement of a police investigation, the victim of a harmful event cannot know how the criminal process will progress. They may not even know who are the individuals who are of interest to the police. And that's obviously why we said, and it was Professor Rosenval's thesis throughout, that the connecting factor was simply one of factual overlap. It wasn't in any way specific to individual defendants, nor indeed to individual causes of action. And indeed, I haven't got time to go for it, but your Lordships can see at supplemental bundle 10A, there's a copy of the announcement of the criminal investigation, which makes no reference to BHP or to any BHP employee, and yet I understand it to be accepted by BHP that that was nevertheless effective to stop time running, at least in relation to certain types of claims against certain BHP individuals or entities. And we say that squarely supports our case, that it is the mere commencement of an overlapping factual investigation which is sufficient. and at the very least, the judge was entitled to form that view based upon the evidence before her. As to BHP's case, your lordships are told at paragraphs 90 and 91 of BHP's skeleton and the accompanying footnotes that their own expert, Professor Tepagino, had referred to the vicarious liability analysis in his first report. If your lordships turn at some point to the references which are at supplemental bundle 38, paragraphs 460 to 461, one sees that he said nothing of the sort. His first report said that the limitation position is personal to the parties, has no effect against non-parties who aren't themselves the criminal defendant, and he had cited none of the cases which had applied Article 200 to persons other than the named criminal defendant. He seems to have overlooked those cases. So what BHP then did was essentially a rear guard action to try and run this vicarious liability analysis to try and reconcile Professor Tepagino's position with the cases which were squarely against him. And we say ultimately the judge was entitled to prefer Professor Rosenbahl's conception as to how it operated. There was some discussion, and it was submitted by Ms. Fatima, that no attempt had been made by either us or the judge to identify the concession in this regard, which Professor Tepagino was said to have made. If we can look at supplemental bundle tab 26, this is L2 tab 29, page 7. Internal mini page 24, line 14. I asked the question, so do you accept or do you not accept that a criminal prosecution of an individual will also stop time running for the purposes of a civil claim against their employer? I do accept it, yes.
Sorry, which page are you on, Mr. Fulton?
So this is internal, the mini page 24, and
yes, got it.
So as Mr. Fulton, you're trying to deal with the lack of time by speaking really very, very quickly.
So I'm trying to strike a balance, my lord. And so there was an absolutely explicit concession there, and I'm slightly surprised to hear that there's some doubt as to where Professor Tepagino is said to have.
And that's you cross-examining Professor Tepagino.
Yes, yes. So he says, I do accept it, yes, if there's prejudiciality, and that's a reference to his argument as to the need for a dependency relationship, which is the separate point. And so because of the employment relationship between Mr. Wilson and BHP Australia, and because of the established principle that it didn't matter whether or not Mr. Wilson was convicted, we said that it was enough to stop time running, that BHP Australia would have been liable for Mr. Wilson's misconduct had he been convicted. And it didn't ultimately matter whether one analyses that in putative vicarious liability terms, which might be said to be the narrow BHP view, or the broader view of an overall factual overlap, because on the particular facts where there was an employer-employee relationship which would have, in the event of a conviction, have given rise to that liability, it was sufficient to stop time running for a claim against an employer because the victim of the event was entitled to wait and see. My lord, so then CDC, BHP's point is perfectly intelligible that there needs to be this base consumer relationship with a consumer end user. The problem for BHP is that the identical arguments that they were running before Mrs. Justice O'Farrell were run unsuccessfully before the STJ by their own JV vehicle, Samarco, in respect of the same collapse and in respect of victims who stood in the identical position. Lords, at supplemental bundle 31, internal transcript pagination 128, line 25 and onwards, we took the judge through the detailed submissions made by Samarco before the STJ, which mirrored precisely the arguments about raw materials and an impermissibly generous extension of CDC, precisely the same points being run by Samarco, but they failed to persuade the STJ, and it was for that reason why we relied upon Mariana. It was by no means the only case relied upon by the judge. It was one of several identified at paragraph 934, alongside cases of Brumagino, which was also a tailings dam collapse, alongside also the case of Wilson, which is mentioned, which was an oil spill collapse, again, an oil spill incident, again, a raw material, not a consumer product, and yet the CDC had been applied. So it takes BHP nowhere to say that poultry and hydroelectric power are examples of things consumed by consumers, because it is obvious from the cases cited by the judge that the STJ has applied it more broadly in relation to events causing consumer accidents in the context of commercial activity. And indeed, that we explained all this in our detailed oral closings and written closings, and all of this is all familiar territory. The judge had it all in mind, and she was perfectly entitled on the material and the recent trend of STJ case law to reach the result she did.
The commercial activity doesn't really get you anywhere, does it?
Well, my lord, the way it's explained in the cases is that where there's an element of exploitation as a commercial activity by the defendant, that's the way the STJ has explained it, and it doesn't matter. And this is explained in the hydroelectric power case cited by the judge. It doesn't matter on those facts whether the electricity is being used by the company itself, whether it's being sold to the government, or whether it's finding its way to a strict sense consumer end user. It is the activity that is detrimental to the environment which engages the protections of the CDC. And that's the direction the STJ has chosen to take, and the judge cannot possibly be criticised for having taken the same approach as had been consistently adopted by the STJ. On the 1932 decree, I have nothing else to add to what we said in the skeleton. Just finally then, on other compelling reason, we say that's particularly fanciful as a basis of appeal on the premise that there's no real prospect, given that this is obviously a series of factual findings. Some of them are Brazilian law, some of them are pure fact. None of them will be binding on any other court, least of all the court in Brazil that might be asked to consider related points.
Yes, I was wondering, what would we do with a Dutch decision on the English law of limitation? I think we'd say, well, forget it.
Well, exactly. I mean, and if it's as all of this is so plainly wrong, as Miss Fatima would have this court believe, then another court looking at this will reach a different outcome. And so we don't accept at all that there is this any prejudice. In fact, all of the considerations are the other way.
That's a bit circular, though, isn't it? Saying that if it is really that wrong, no one else will pay attention.
Well, my lord, there is no binding effect. I can put it that way. That there is no reason, there's no imperative for this court to review things. What there is, however, would be the enormous disruption and uncertainty in the context of a huge Stage 2 trial next year, which is currently being prepared for. If this court, without being satisfied there was a real prospect of success in relation to the arguments, were to inflict on the claimants an appeal, and as BHP would have it, indeed a partial retrial on this curious documents-only basis. So we say that the real prospect, the other compelling reason ground certainly adds nothing to what is already we say a hopeless appeal.
Right, thank you very much. Well, I don't think you're entitled to reply on an application for permission, Ms.
My lord, I don't, and so it's really with the court's indulgence. It's on that point that was just identified for the first time, the concession of that Professor Tepedino. This is the first time that's been identified. Could I just invite the court to please read the 5 pages that I brought to your attention, because you will see what prejudiciality means. It includes vicarious liability. So that is the only point I wanted to make.
Can you just tell me what the 5 pages are again? Just give me the
Of
reference.
the transcript.
Ah, yes.
I gave you the reference.
One that we looked at.
Exactly so. Exactly. This is amongst those, and you will see what he's referring to if you read those.
And I have got one question for you just on a reference, and you don't need to give it to me now. This morning at page 20 of the office transcript, you referred to a particular part of the expert's joint statement.
Oh.
If you can, please don't trouble yourself with it now, but if you could just send me the exact reference and
Yes,
the
of
paragraph
course.
number.
Yes.
just for very quick.
Yes, of course, my lord.
Right, thank you very much. Well, although it's unusual, we will reserve judgment on this application for permission to appeal. You will get a draft in the usual way, which will come with an embargo, which means what it says. So it can only be distributed to those whose distribution details have already been given to the court. It must go no further. In the light of the draft judgment, we would hope that you would be able to agree an order disposing of the application. And in the event that we grant permission to appeal on one or more grounds, we would ask you to consider what directions, if any, need to be given for the disposal of the appeal, and what, if any, directions ought to be sought from a lower court pending the outcome of the appeal. Thank you very much.
All rise in favour.
Sorry, just a minute.